8 women that you strangled to death? At least 8 that we know of? Are you at least a little bit sorry for that? Yes?
Yes, I am.
Imagine sitting in a courtroom just a few feet away from the person who permanently changed your family forever. Imagine waiting 16 years for that moment, only for him to sit there staring blankly at a wooden table. For more than a decade, he was a ghost. For the last 3 years, he sat in total silence. But in his final minutes as a free man, the Gilgo Beach defendant was finally forced to stand, face the bench, and hear the court speak directly to him. And what happened next was something the New York court system almost never sees. A judge stripped away the entire image of a mass offender on the official record. No lies, no guessing, no speculation. This is the exact verified breakdown of how Rex Heuermann's final court appearance erupted. If you want strictly factual, deep dive legal breakdowns without the fluff, hit that subscribe button right now and join us here at US Crime Stories.
You know what? You've been described as a very big man, but you're a disgusting and despicable small man, if you're a man at all. And you're a coward.
So let's talk about what actually happened inside that courtroom. To understand the weight of those final minutes, we have to stay with the facts established inside the Riverhead, Long Island courtroom on that specific day. It was June 17, 2026. The atmosphere inside the room was incredibly heavy. Everything was controlled by the strict legal procedures that come at the end of a massive multi-year judicial process. The gallery was packed to its legal limit. For a case this large, the court had to set up overflow rooms just to handle the number of credentialed media members and public observers who showed up. According to reporters on the ground, the security presence outside the Riverhead courthouse was intense. There were layers of metal detectors and a heavy police presence around the perimeter. Inside the main courtroom, court officers lined the walls and stood at attention. Under official protocol, they were there to maintain order in a room filled with people who had waited well over 10 years for this exact court date. Wow. When you really think about waiting that long for one single day in court, you start to understand how much pressure was sitting inside that room. To fully understand the gravity of this moment, we have to rewind and look at what it took just to get this man into that chair. According to official police records, this investigation had haunted the community since the winter of 2010. That was when law enforcement first made the grim discoveries along Ocean Parkway. For years, the victims' families were left with unanswered questions. Police hit dead end after dead end. The case was complicated, cold, and for a long time, it felt like it might never move forward. But then, as documented in major bail applications and court filings, the investigation shifted. Investigators used advanced cellular data. They tracked old burner phone locations. They matched a tiny fraction of DNA from a discarded pizza crust to evidence connected to the original scenes. According to the prosecution's verified timeline, it took careful, exhausting police work to finally make the arrest in July 2023. We are talking about 16 years of waiting, followed by 3 years of one of the most complex pretrial discovery phases in New York history. According to prosecutors, they turned over terabytes of data to the defense. That included thousands of pages of documents, forensic reports, digital evidence, and investigative material. Judge Timothy Mazzei, who presided over the case, had to navigate all of those massive legal hurdles just to get everyone to this sentencing date. So by the time everyone finally sat down on June 17th, the legal foundation was already locked in. The jury had spoken. The debate over his guilt was officially over in the eyes of the law, and I understand why the tension in that courtroom felt so thick. Now, seated in the front rows of the gallery were 13 family members of the victims. And this is where the human part of the story has to be centered. For these families, walking into a courthouse was not just about showing up for another hearing. It meant reliving the darkest part of their lives in a public room under legal rules while sitting close to the person responsible. During a trial, the process is slow, rigid, and controlled. Families have to sit through hours of technical testimony. They have to hear painful details discussed in clinical language. and they have to do it in silence. Courtroom decorum is strict. If a family member cries out or reacts too loudly, a judge can remove them to protect the jury from being influenced. But sentencing is different. Under New York state law, sentencing serves a different purpose than trial, and that is a major shift. The trial is about proving facts. Sentencing is about consequence. At this stage, the presumption of innocence is gone. The state has met its burden. The conviction is in place. This is the point where the state, and more importantly, the victims' families, finally get protected time on the official record. When we talk about centering the victims, we also have to acknowledge the strength it takes to stand up in that room. The families did not just show up. They brought the memories of the people they loved into a cold legal space. According to court records, each statement was carefully prepared. The families had to coordinate with prosecutors to make sure their words met the legal requirements for victim impact testimony. That means they could not simply say anything they wanted. They had to focus on how the crimes directly affected their lives, their health, and their families. To stand at that microphone, knowing the person responsible is sitting just feet away, takes a level of courage that is hard to fully understand. Holy cow. The hearing transcripts show exactly what the families chose to say when it was finally their turn. Victim impact statements are a crucial part of the justice system. They exist so the court is forced to confront the human cost of the crime, not just the penal code violations written on paper. And these statements were direct. They did not hold back. Multiple family members walked that long aisle to the microphone. They stood there looking toward Heuermann and spoke into the record. They called him disgusting. They talked about the permanent emptiness left behind in their lives. Another family member, speaking about the severity of the acts and the limits of a human lifetime, said clearly into the microphone that 1,000,000 years isn't enough to balance what had been taken from them. Holy moly. When words like that become part of the permanent court record, it puts the reality of the case into a completely different perspective. And how did the defendant react to all that grief? Heuermann, who was 62 years old at the time of the final hearing, sat at the defense table. According to multiple court reporters inside the room, his movements were almost non-existent. He lightly tapped his fingers against the wooden table. That was it. That caught me off guard. You are sitting there listening to the devastation tied to your actions, and your only visible movement is tapping your fingers on the table. Reporters noted that he did not turn around to look at the gallery even once. He did not make eye contact with the grieving family members who walked up to deliver their statements. He kept his eyes forward or focused downward at the desk. Through all that heavy emotional testimony, the defendant maintained the same stoic posture he had held through 36 months of hearings, motions, and trial proceedings. He sat in silence. He let the words enter the courtroom air and disappear into the court reporter's stenograph without any visible emotional reaction. Now, to present both sides of how this works legally, we also have to look at the defense counsel's role. Defense attorneys almost always advise their clients to remain silent and avoid showing emotion during these proceedings. Why? Because anything they say or do can potentially be used against them in future appellate arguments. The defense strategy is about preservation. They want to avoid any outburst or statement that could justify a harsher sentence or damage a future appeal. So from a strict legal standpoint, his silence was a textbook move advised by counsel. But from a human standpoint, inside that room, it was deeply unsettling for the families to witness. It is also important to understand the pressure sitting at the defense table in those final moments. Under standard legal practice, defense attorneys watch their client closely during the allocution phase. If the defendant goes off script and says something inflammatory, it does not only affect the sentence. It can affect the entire narrative of the trial they just fought through. They prepare for this. They counsel their clients on what to say and what not to say. But once the microphone is turned over to the defendant, control shifts to the person in the chair. No way. You spend years building a legal strategy, and then everything comes down to what that person decides to say in his final moments before sentencing. But the real climax of the hearing, the exact moment the entire dynamic fractured, began when Heuermann was given his legally required chance to speak. New York, like many jurisdictions, requires that a defendant be offered the opportunity for allocution. If you have never heard that word before, allocution is the formal statement a defendant can make directly to the court before the final sentence is handed down. It is the one moment where the floor belongs completely to the convicted person. Their lawyers cannot speak for them in that moment. What happens during allocution often sets the final tone of the judge's ruling. It is designed as a moment of public accountability. Some defendants use it to apologize, others maintain their innocence. And in that Riverhead courtroom, the pressure between the defense strategy of total silence and the judge's demand for legal accountability was about to ignite into a massive confrontation that would go down in legal history. So right after the last family member walked away from the microphone, the formal part of the hearing finally reached its end. The documents had been entered into the record, the attorneys had made their final standard motions, and then the courtroom went completely silent. It was that heavy kind of silence where everyone in the room knows the entire multi-year legal process is now coming down to one single moment. Judge Timothy Mazzei looked down from the bench and fixed his eyes directly on the defense table. And if you look closely at the verified documents, the next exchange comes directly from the official court transcript from June 17th, 2026. Judge Mazzei did not gently ease into this part of the hearing. He gave a hard, direct order. He did not ask politely. He did not wait for the defense attorneys to guide their client. The court said, "Stand up." Heuermann stood up from his chair and faced the bench. Now, legally, this was the exact moment where the court, the grieving families sitting just a few feet away, and the public all expected him to say something. Under New York law, this is called allocution. It is the specific moment when a defendant is legally allowed to speak directly to the judge before the final sentence is given. And when you look at this fairly from both sides of the legal aisle, different defendants use allocution in different ways. Some defendants use the moment to apologize, hoping to show even a small amount of remorse before sentencing. Others use it to insist they are still innocent. Some use it to complain about the police, the prosecution, or the way the trial was handled. But Heuermann chose a completely different path. He gave a short, careful, and highly calculated response. He stood there, looked toward the bench, and said this word for word, "There are no words I can say. The words I would say have no meaning, and I'm going to leave it there." Wow. When you read that in the official transcript, it really stands out. From the defense side, this was actually a pretty standard legal move. Defense attorneys usually tell their clients to say as little as possible during sentencing. Why? Because every word spoken on the record can later be studied, challenged, or used in appellate arguments. By saying his words had no meaning, he technically responded when the court gave him the chance to speak, but he avoided making any direct factual admission about the crimes. It was a legal shield. But from the side of the victims and their families sitting behind him, that answer was devastating. They had waited well over a decade for truth, accountability, and maybe even some kind of human response. And in his final chance to address the pain tied to his actions, they were met with a cold verbal wall. Why not subscribe to US Crime Stories right now so you never miss a single factual breakdown of these major legal cases we cover here? In many courtrooms across the country, a judge would simply accept a short, empty statement like that. The judge would nod, read the sentence into the record, close the file, and move on to the next case. But Judge Mazzei did not let that answer stand without a challenge. That caught me off guard. You do not always see a judge push back against a defendant's silence, especially when the legal outcome is already basically decided. But Judge Mazzei used his authority in that courtroom to press him directly. He demanded a clear answer about whether Heuermann actually felt remorse before the final judgment was handed down. Mazzei leaned into the microphone. His questions were sharp, direct, and unrelenting. The court said, "Are you a little bit sorry for what you did for these poor innocent women? Are you at least a little bit sorry for that?" The whole room waited. You can only imagine how still the gallery became in that exact second. By asking a clear yes or no question, the judge cornered the defense in front of everyone. If Heuermann refused to answer, he would be openly ignoring a direct question from the judge on the official record. So, forced to respond to the authority of the bench, Heuermann gave a short, quiet answer. "Yes, I am," Heuermann replied. Right. That small three-word answer was all Judge Mazzei needed before delivering his final documented rebuke. The judge's voice rose and filled the Riverhead courtroom. And what made this moment so striking was that he did not hide behind confusing legal language. He did not bury his point inside complicated statutes or procedural wording. He spoke directly to the 62-year-old defendant and placed the court's moral judgment on the public record. "You are disgusting, a despicable man if you are a man at all," Judge Mazzei said firmly, "and you are a coward." Holy cow. When a sitting judge says something like that on the official record, it carries serious legal and historical weight. And the judge did not stop there. He continued his verbal takedown, choosing his words carefully as he dismantled Heuermann's tiny show of remorse. According to the transcript, Judge Mazzei made it clear on the record that he did not believe Heuermann was truly sorry for the lives he took. The judge stated that Heuermann was only sorry he had been caught by law enforcement. He was only sorry for the permanent damage he had brought onto his own family's name and reputation. It was a public stripping away of his personal and legal defenses. Now, when you look at both sides of how this moment was viewed in the legal world, it sparked a lot of debate. On one side, prosecutors and victims' advocates strongly support this kind of judicial intervention. They argue that the judge is the voice of the community. By calling him a coward on the record, the judge validated the unimaginable pain of the victims' families and acknowledged the severity of what they had endured. It centered their experience. It made sure the human cost was officially recorded. But on the other side, some strict legal purists believe judges should always stay detached and clinical, no matter how disturbing the case is. Their concern is that emotional reprimands from the bench can sometimes give defense attorneys a small opening to argue that the judge showed bias against their client. But in that specific courtroom, on that specific day, Judge Mazzei made sure his view was the final word. After the reprimand, with the tension in the room at its highest point, Judge Mazzei moved straight into the official sentencing. His tone shifted back to the mechanics of the law. He read the sentence neutrally and followed the New York State Penal Code exactly as written. For the first-degree murder charges, Rex Heuermann received consecutive life sentences without the possibility of parole. For the second-degree murder charges, he received consecutive 25 years to life sentences. And I really want to break down what that means, because in legal terms, the word consecutive is one of the strongest penalties a judge can give in a state without the death penalty. When someone is convicted of multiple crimes, the judge has to decide whether the sentences will run concurrently or consecutively. If the sentences run concurrently, that means the person serves them at the same time. The clock runs on all the charges together. But consecutive means the sentences are stacked one after another. So when one life sentence theoretically ends, the next one begins. And after that, the next one begins. It is a harsh mathematical certainty designed to make sure the defendant never walks free again. There is no good behavior credit that can undo consecutive life sentences. There is no future parole board that can simply erase the math. By choosing the word consecutive, the court officially shut the door. The legal system made sure that the families would never have to sit through a parole hearing decades later and beg the state to keep him behind bars. The finality of the judge's ruling was absolute. As soon as Judge Mazzei finished reading those consecutive sentences into the official record, the aftermath moved fast. You really have to picture that room to understand what it felt like. For years, the people sitting in that gallery had been forced to hold everything in. They had to sit quietly while the court controlled the schedule, while the defense made its arguments, and while the legal system slowly moved forward, step by step. But the moment the finality of those sentences hit the air, the tension in that courtroom completely broke. Judge Mazzei had completed every strict legal requirement of the sentencing hearing. The law had been satisfied. He looked down from the bench, past the defense table where Heuermann was sitting, and made direct eye contact with the court officers standing near the walls. According to the official record, the judge did not use formal legal language for what came next. He did not quote a statute. He did not read from a binder. "Get him out of here," Mazzei snapped. Right there, the sentence became physically real. The heavy metal click of handcuffs echoed near the defense table. That sound marked the absolute end of the road. Court officers quickly surrounded Heuermann and began leading him toward the side door, taking him back into state custody. And that was when the gallery's restraint finally dissolved. You can only hold back for so long when you have carried that kind of pain for more than a decade. The courtroom erupted. Family members, friends, and other attendees broke into loud applause. Then, over the clapping and emotion, one specific chant started coming from the gallery. "Ogre. Ogre. Wow." Now, if you are only recently following this case, that might sound like a random insult thrown at a man in handcuffs during a heated courtroom moment. But it was not random. That word carries deep history in this investigation. It was a direct callback to the nickname tied to a witness description of the unidentified suspect all the way back in 2010. Police said that description was a major early turning point, but for years, it led nowhere. The victims' families had to live with that word, ogre, sitting in the background of the case, wondering if the person connected to it would ever be found. 16 long years after that description first entered official police files, those same families were chanting that word at the man being led away to prison. That caught me off guard when I first read the transcripts. But once you understand the history behind it, the moment feels completely different. It was full circle. They took a word that once represented a ghost, a faceless fear in their community, and they threw it directly at the man who was finally being locked away. It was their way of saying, "We know exactly who you are now, and you are not hiding anymore." The legal reality of June 17th, 2026 is final. Rex Heuermann will spend the rest of his natural life inside a maximum security New York State prison. Police said the multi-decade investigation is officially closed. There are no more bail hearings to worry about. No more discovery phases. No more trial delays. For the families who endured that long, painful wait, the system finally delivered the highest structural penalty available. The doors are locked. The state has permanent control of his future. But even though the sentence itself is fixed, Judge Mazzei's actions during those final 10 minutes leave behind a much bigger legal debate. Was the judge's intense verbal reprimand justified, or did it cross the strict line of judicial standards? To look at this fairly, we have to understand how the law views the behavior of judges during sentencing. This is a heavily debated issue among lawyers and legal scholars, so we need to look at both sides. Let's start with side A. The argument supporting the judge's rebuke. Legal professionals who support this kind of courtroom response often point to a concept called therapeutic jurisprudence. I know that sounds like a big legal phrase, but the idea is actually simple. For years, the justice system has been criticized for treating victims like evidence instead of human beings who suffered real loss. Supporters of therapeutic jurisprudence argue that during sentencing, the judge represents the voice of the state, the community, and most importantly, the victims. Once a conviction is secured and the presumption of innocence is gone, the judge has broad legal authority to express moral outrage on the record. They argue that the court should explain why the maximum penalty is being imposed, not only in cold legal terms, but in human terms too. So when a judge calls a defendant a coward or disgusting on the record, supporters say, it gives the grieving families a powerful sense of legal validation. They finally hear the system acknowledge the horror of what they went through. I see the point. It is about making the law feel human to the people who suffered the most. The judge made it clear that the sentences had to reflect the full gravity of the acts committed. Supporters also argue that this serves a practical legal purpose: deterrence and record building. By putting a firm, unfiltered statement into the official case file, the judge makes sure any future appellate court understands how severe and depraved the crimes were from the trial court's point of view. It locks the emotional and factual weight of the sentence into history. If an appeals court looks at the file 20 years from now, they will not just see numbers and legal codes on a page. They will also see the outrage of the judge who presided over the case. Holy cow. When you look at it that way, you can understand why prosecutors and victims advocates often want judges to speak clearly and firmly in moments like this. But then we have side B, the criticism of judicial outbursts. On the other side, strict legal purists argue that judges must stay detached, calm, and clinical at all times, no matter how terrible the crime is. They point directly to the rule book. The New York Code of Judicial Conduct states that a judge must be patient, dignified, and courteous to every person in the courtroom, including defendants. Critics of Judge Mazzei's approach argue that name-calling, even against a convicted multi-victim offender, can lower the dignity of the bench. Their argument is simple. The court is supposed to stay above the chaos. The judge is supposed to remain a neutral referee, even at the very end. There are also real practical risks that defense attorneys watch closely. In some cases, aggressive or emotional language from a judge during sentencing can become ammunition for the defense later. On appeal, defense teams can try to use those exact transcript quotes to argue that the judge was personally biased, vindictive, or failed to remain impartial. If an appellate court agrees that the judge crossed the line from legal authority into personal hostility, it can sometimes lead to long, painful, and expensive resentencing hearings. No way. Yes, that can actually happen. If a sentence is overturned because of judicial bias, the sentencing phase has to be done again. That means the victims' families could be forced to return to court, sit in that gallery again, and relive their impact statements all over again. So, from that side of the argument, the judge should simply read the sentence and let the prison time speak for itself. By staying clinical, the judge protects the conviction from procedural loopholes that the defense might try to exploit later. It is a protective measure meant to make sure the families never have to face the offender in court again. When we step back and look at the full picture, we have to center the families who walked out of that Riverhead courthouse on June 17. They walked out knowing the man who changed their lives forever was now fully in state custody. The legal mechanics worked. Police said the evidence held up. The court said the penalty was final. We shared this breakdown because the tension between human emotion and cold legal rules is one of the only ways to truly understand how the justice system works in major cases like this. It is never just black and white. It is a complicated system built by humans, for humans, to deal with some of the darkest parts of society. The reality is that the legal system has to balance the raw grief of victims with the strict clinical rules of the courtroom. And when those two forces collide, you get moments exactly like the one between Judge Mazzei and Rex Heuermann. The families saw the man responsible for their nightmare held fully accountable, stripped of his silence, and sent away forever. The system did what it was designed to do, even if the final moments sparked a serious debate about judicial decorum. Now, we want to hear your take on how this played out in court. Look at the facts, the transcript, and the legal debate we just discussed. Does a judge have a moral duty to verbally condemn a severe offender on behalf of the victims? Or should the massive sentence itself do all the talking? Where is the line between a judge showing justified community outrage and violating the strict judicial code of neutral behavior? And did the defense's minimal statement force the judge to demand a clear answer about remorse? Drop your thoughts below so we can discuss it. Thank you so much for staying until the end. Please subscribe to the channel and do not miss the next video we post for you.